This is Eleanor Curry with the Curry Law Firm and coronaviruslegal.us. I'm here sharing information and updates about COVID-19 and how we can anticipate it will impact our economy, legislation, small business, and of course, our health. Today we're focused on the Families First Coronavirus Response Act and its impact on not just employees, but also employers and small businesses who are dealing with the impact of the coronavirus. This legislation expands paid sick leave and family or medical leave for reasons related to COVID-19. It will apply from April 1st, 2020 all the way until the end of the year, so it's pretty important for employers. Now, for employees covered under this act, they will be eligible for expanded sick leave in a couple of different arenas. First, they are eligible for 2 weeks of paid sick leave at the employee's regular rate of pay, where the employee is unable to work because the employee is quarantined pursuant to a government order or at the advice of a healthcare provider. This also applies if they're experiencing COVID-19 symptoms and seeking a medical diagnosis. They also are eligible for 2 weeks of paid sick leave at 2/3 the employee's regular rate of pay because the employee is unable to work because they are either have a bona fide need to care for an individual subject to the quarantine, or if they are having to care for a child who is under the age of 18 and their child care provider is closed or unable to provide service due to COVID-19. So that's for 2 reasons that they're eligible. It also slightly expands for employees that are experiencing symptoms that are substantially similar to those conditions of COVID-19. Finally, we also know that employees are eligible for an additional 10 weeks of expanded sick leave at 2/3 the employee's regular rate of pay when the employee has at least been working for at least 30 calendar days and there is a bona fide need to leave to care for a child. The same and similar circumstances apply that the child care provider had to be closed due to a rollout of COVID-19. Now, this applies to employees that have an employer that has less than 500 employees, so that's a huge range of employers that it will apply to. Employees who have qualifying reasons to leave are eligible under this plan, and let's revisit some of these qualified reasons because it's pretty important and it really puts a big burden on small businesses that are already facing financial distress, that they are also expanding and covering sick leave and time off to care for children under the age of 18. So let's revisit those particular reasons. First, if they are subject to a federal, state, or local quarantine or isolation. Second, if they have been advised by a healthcare provider to self-quarantine. Third, if they are experiencing COVID symptoms and out seeking a medical diagnosis. Fourth, if they are caring for an individual subject to statutory mandated or healthcare provider advised quarantine. And finally, if they are caring for a child whose school or place of care is closed or unavailable for reasons related to COVID-19. We also know that if they are experiencing symptoms substantially similar to COVID, chances are they qualify under this particular plan. Now, this plan is pretty expansive, and we're going to talk about the rollout not only to employees, but also to employers who are now responsible for this expanded sick or medical leave all week. So make sure you like, share, and subscribe to get details and updates about the Family First Act and other legislation and economy plans that impact you and your business due to COVID-19. So like, share, and subscribe to coronaviruslegal.us and make sure to stay tuned as we provide daily updates.